Invention.
Well, item number 24, I am for the respondent district council, my lord. I have received the record, my lord. So there are certain documents which are in Garo, my lord. So I've taken
22?
24, my lord. 24. So I've taken concern of my senior and my friend. My lord, if 1 week can be given to me so that at least I will see whether it is.
What record can be given to you?
The record, my lord, of the lower court I have received.
What's the matter about Mr. Moment?
Yes.
This is
Hacking matter?
Yes, my lord. Now,
What
certain.
records are there that are so important? We need orders of the EM and CM enough.
No, my lord, Mozilla reports and all are there. It's in Garo, my lord. Only I need to know what exactly they have written. So only 1 week I will pray, my lord. This matter can be taken up next week.
Very difficult to get my friend. Fortunately.
ready, my lord.
Yes. After 1 week, as on the prayer, Mr. SD, to enable him to decipher some documents.
Item number 32, my lord. I am for the petitioner. Let this matter also be listed next week, my lord. I have taken concern of my learned senior friend from Union. Next week, my lord.
Yes, 2 weeks.
Let it be next week, my lord, because some admission, we are applying for some admission, my lord. One document is required from Delhi. Only for that, my lord. Otherwise, next week.
Please, Your Lordship. Item number 23, my lord. I have the consent of my friend.
23 or 22?
23, Lord. 23. The matter may come up after 2 weeks, my lord. I'm seeing for 2 weeks adjournment.
What's the problem, Mr. Gota?
My lord, I have little difficulty today, my lord. Some personal difficulty.
Just don't feel like doing hearing.
My lord?
Don't feel like doing hearing today.
Not exactly, my lord. I have some other obligation.
Okay.
Obligation.
May I please, Lordship, I beg to mention item number 26. I pray that the matter may be taken up after 2 weeks. Item 26, Lordship.
Who's for the petitioner?
I've
You informed them?
already informed him yesterday.
After a week.
Mr. Chanda?
No, this is that ACR matter. This is that ACR matter, Lordship. Upgradation of ACR.
Has already been heard.
I'm supposed to come with judgments, Lordship, but since they've not, the council is not there.
He's on sanction leave, Lordship.
After 1 week, Lordship.
That is on the verge of completion because the thing is that. Anyway.
After 1 week.
That's what happens. The once the matter is heard, then it just gets.
Lordship.
It's 1 week, okay.
After 1 week.
Are you obliged?
Please, Lordship. Lordship, I beg to mention item number 27, Lordship.
Why?
Lordship, some difficulties, Lordship.
Who's for the side?
Lordship,
You've taken a
ACDC,
consent?
Lordship. I'm praying for 2 weeks' time.
For a private respondent, Your Lordship.
What about the state? Or what is this? KHDC? Who's the parent?
ACDC, Lordship. It's not here, Lordship. 2 weeks' time, Lordship.
Yes.
Deeply obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 28.
Yes.
Lordship, Contracting Council PPP board has some difficulty at his native place due to some medical emergency of his parents. Lordship, can it be in the month of August?
Month of August. Okay, we'll listen July after this. After 4 weeks, yes. Okay.
May I please, Your Lordship, I beg to mention item number 31, Lordship.
Yes.
Due to personal difficulties, Lordship, after 2 weeks, Lordship.
31?
Yes, Lordship.
No objection.
Yeah, objection?
No objection.
You all do not do cases. Yes, 2 weeks.
Highly obliged, Lordship.
Supplementary, this item number 1.
Yes.
For appointment of arbitrator. Yes, Your Lordship. The matter is appointment of arbitrator. I filed this under section 11.
When is the contract over? When is completed?
Your Lordship, I have executed the work on
Contract of which year?
2019, Your Lordship.
2019 finished.
Oh no,
When
Your
did you
Lordship.
make the
This year finished. 2025.
And when did you make the request?
26/03/2025. I have sent a notice on, Your Lordship.
Where is that notice? Which
24/05/2025. This is Annexure 4, Your Lordship.
page?
35 to 73 also.
Page
35.
35. (24)(5). So just about 30 days over.
Yes, sir.
Yes.
Allow Mr. Consolidation.
What's your name? Your name?
H. Mia.
That was H. Mia, then Constable the petitioner. Issue notice. Dr. N. Mozika with so-and-so is present. Accept notice. So no further notice is required. List after 2 weeks for instruction. Affidavit.
Item number 2.
My lord, these matters are related to the lead case. My
We'll
lord.
take it other matters together.
Yes, my lord. Item number 2, my lord, in supplementary 16 to 19, my lord. And
Item number 2 in supplementary, then item 6 to
then
19.
2 and 3, my lord. 2 and 3.
In the main cost case also, my lord. Item number 2 and 3. are
And
the
16 to
lead case.
19.
2 and 3 and 16 to 19 also.
Also, my lord. And 21.
My lord.
So all connect.
16
to 19
and 21.
and 21.
We'll finish our yes, we'll take it with the main list.
My lord, this matter, they are yet to file affidavit.
Which one?
The
In
lead case.
matter, I have
item
filed the
number-
affidavit, my lord.
We'll take it up together. Let it be called out.
Yes.
With the when the main when the main in the main list is number 2 also.
Number two,
Number
three.
2, my lord. Number 2.
Call out motion first.
Item number 3.
May it please your lordship. My lord, this petition, we are constrained to file this petition, my lord, because we have filed a bail applications, my lord. We have filed a bail
What
application.
application is this? This is the 226.
226, my lord, because it concerns the right of personal liberty of the. Yes, my lord.
It's bail?
It's maintainable. It's not per se a bail, my lord, but this is maintainable. Why? Because the bail application has been arbitrary without any plausible ground has been adjourned for 14 days, my lord. We have moved a bail application. Now, initially what happened was, my lord, I was accused of committing a double murder, my lord. Double murder. And
Yes.
I was also alleged of fathering an infant child, my lord. Fathering an infant child, which I claim, I say that I am not responsible for the child, for the birth of the child. I'm not the father of the child. And I've been saying that let's go for a DNA test. There was a dispute to that. And then suddenly,
The child dead.
no, suddenly the mother and the child died, my lord. Both of them, they died. They were found in the water tank, my lord, in the small dam, my lord. This is in Langtor, my lord. So the first suspect goes to me, so I got arrested. Now all my bail applications all along have been rejected. While I was saying that let's go for a DNA test because the DNA test will speak for itself. Now finally, my lord, on the 90th day, they filed a charge sheet. They filed a charge sheet and the charge sheet says, even the DNA result has come. It says that I am not the father. Not one thing. Now the second thing is that all along my bail have been denied because of committing a double murder. Now the police says, in the charge sheet says that no, there is no evidence of murder. But they charge me under abetment to commit suicide now. Now who is the father? Where is the proof of commit suicide? Therefore, my lord, with this change of circumstances, I filed my bail applications,
When
my
did
lord.
you file it?
I filed my bail application on 23rd of June, my lord. 23rd of June. But unfortunately, on that day, for whatever reason, I don't know, they did not register. And they registered the bail on 26th of June. 26th of June, that is, they said because there is a day of the production. 26th of June, along with the case, charge sheet, my lord. Now, on 26th of June, we went to move the bail on a changed circumstance, as I said. Now, for any reason, my lord, adjourned the bail application to 14 days. This is 10th July, my lord. Now, my lord, bail application and the charge sheet or consideration of charge has nothing to do, my lord. Supreme Court says even 1 day bail application should not be adjourned, my lord. So I have one small judgment to that effect, my lord.
First, why become a petition? Is that a petition criminal?
My lord,
Should be under criminal, WC criminal.
it can be under 482, my lord, or in a new law. It can be under 226 also, my lord.
See, even
Yes. My lord,
there's a big distinction also between ordinary 226, we asking for other writs, represent criminal, and a 482.
my lord, my lord,
482 is for the fair absence of just criminal justice.
my lord.
Then criminal writs we can file enforce rights or wrongs, like you say. So if it would have been better if because criminal is very broad also. It can even take into account fundamental rights.
My lord, but 226 also does not bar me, my lord, because if my lord will see my prayer, my lord, I'm only seeking for a direction.
I understand that, but then
Yes.
the correct procedure should already be adopted.
My
482 also is available to you because it's for fair administration of justice. We can inherent powers can be invoked.
My lord, because now, my lord, since
Although it's limited to making orders within the CRPC or the BNS, whatever.
Yeah.
Now, BNS.
But my lord, because 227, my lord, 226, 227, my lord, I don't, my lord, only, my lord, what my prayer is, my lord, because in the fit case, my lord, even under 226 also, my lord has the power to give bail, my lord.
No, there's no what 226 is the ultimate. I mean, is the last resort.
My lord,
Understand
my
that?
lord.
You have other remedies
lord.
which are more specific.
Yes, my
482, like I said, it deals only with criminal justice. To
my
ensure
lord.
fair administration of justice,
Yes, but-
and to
yes.
seek inherent invocation inherent parts of
Yes.
this court. So 482 would have sufficed also.
My lord, I quite follow, my lord, what
Because
my
in
lord
fact
has.
is that
Yes.
it is you have come sort of a complaint against the order dated 26th of June.
My lord, my lord.
Anyway, I don't want to argue with you. Yes.
May it please his lordship. Lordship, this is a criminal matter, lordship.
Yes.
There is no way for filing a civil. 226 is a civil remedy, lordship. It should have been filed under the 482 or under the new court.
You can find other witness criminal also.
Yes, my lord.
But
Paragraph
it goes to
4.
different bench.
I'm sorry, my lord.
It goes to different bench.
Lordship,
My lord,
yes.
because
it
this
cannot
will
be
again,
by
my
a
lord,
civil by a civil writ petition, your lordship.
My lord, the directions can be always given, my lord, under 226. There's no bar, my lord. Only paragraph 4, my lord. Kindly have a look. Paragraph 4, my lord. It says that, my lord, it has.
Yes, I think it came on the news. The bail application was kept pending for years, I think.
Yes, my lord. Yes, my lord. And also, my lord, just recently, my lord, yesterday, I believe, my lord, the registry is.
That is from Madras High Court, your lordship.
My lord.
Madras High Court.
But it says that it has been observed by this court, even a single day delay in deciding the bail application adversely affect the fundamental rights of the citizens, my lord. So here, my lord, my right.
Okay, as a special case, we'll dispose of the matter.
My lord, with a direction.
Without
My
giving any, observations on,
my
whether it
lord.
should have gone by A, B, or C.
My lord.
Since if the facts, what you say is correct,
It is correct, my
Let's see
lord.
the annexures, which is the next. Where's the 26th order?
Lordship, there is a statement at paragraph 5, your lordship, at page 4. Lordship, before coming to, if Lordship kindly come to page 4 at paragraph 5, there is a statement made, your Lordship, whether this statement is correct or not, your Lordship, because the learned session judge has been made a party in the writ petition.
So let's see,
also.
let's see the downloaded copy, annexure 4. Let's see.
Annexure 4, my lord.
That will settle the issue. Page.
This is page 43, my lord. Page 43, bail application, so and so. Date of filing 26th, registration 26th, and next first hearing 26th.
That is what case number, FR number, so filing date 26.
Yes, my lord.
Registered on 26 only.
26, my lord. 26th.
Yes.
And then, my lord, will the next date of hearing is 10th of July, my lord.
Yes.
10th of July.
Yes, it's there, Mr. Right. Where's the DNA report?
Charge sheet, my lord. I will just extract of the charge sheet I've given, my lord. That is a
Page
forensic.
42, your lordship.
Forensic report, page 29 is a forensic report, my lord. Where was it?
Page 42 is the finding, your lordship.
And page 31, my lord. Page 31. That is the forensic report, my lord. DNA report. The last in a bold letter, my lord. May I just read the DNA profile?
Yes.
Yes.
Not the visiting father of the
Yes. Yes.
Oh, the baby also died.
Baby also died,
Very
my lord.
unfortunate.
That's very unfortunate, my lord. The police is actually supposed to find out who is the main culprit. They got me, media already convicted me, the entire village convicted me, and I all alone have been saying, please let's go for DNA test.
Lucky didn't execute you. Only conviction.
My lord, I'm very
Mob
fortunate, my lord.
Very dangerous, yes.
I'm not a victim of the mob
Yes.
launching.
Yes, sir. Mob lynching, yes.
Mob lynching.
You thought third, Mr. P. Ubin, the Consolidation issue notice. Issue notice. Mr. Andy Shulai is present. AAG with sponsors present behalf of 1 and 2. No
1 and 2, your lordship.
In confliction nature matter, no notice deemed necessary to the respondent number 3. Stop. The complaint of the petitioner before this court is that the non-consideration of the bail application filed by the petitioner on 26/6/2025, which he submits has infringed upon his personal liberty and other rights. Mr. P. Ubin submits that the petitioner was arrested on
4th of March
4/3/2025 on an allegation of committing murder and has been in custody till date. Stop. It is submitted that multiple bail applications were filed and rejected while investigation was ongoing. But after the investigation, a charge sheet has been filed dropping the murder charge and the murder charge, and the same has been modified to abetment of suicide, which is a less serious offence. Stop. On the changed circumstances, the legal counsel submits fresh-based applications for file. But however, the learned sessions judge, bracket respond number 3, has fixed the matter after 14 days. Stop. To substantiate this contention, the learned counsel has drawn attention of the court to Annexure 4, wherein the extract of the CIS is annex appended, showing the next date fixed. The petitioner therefore prays that the directions be issued that the bail application be taken for consideration immediately. Next part of Mr. Andy Island AG, learned counsel with so and so for the respondents has raised objections as with regard to the maintainability of the writ petition, and submits that the writ petitioner has can take recourse to other remedy available, whether by writ petition criminal or under section 482. Stop. He therefore prays that the matter not be entertained at this stage. Next paragraph. Upon hearing the counsel of the parties, it is noted that the only issue in the present matter is with regard to the non-taking up of the bail application filed by the petitioner on changed circumstances. Stop. It is also noted from the records that the charge sheet has already been filed, and the I'm sure of that. Swagata. only regardless of the petitioner, not by the petitioner. In the changed circumstances. Next paragraph. Though the submissions of the learned AAG also noted, in as much as maybe records could have been taken to, maybe the person resorted to filing of a writ petition criminal or application of section 482, which deals with the fair application of criminal justice. Stop, in the circumstances, without adverting to those contentions, it is directed as follows. Stop. The discussion judge, which district?
Nongstoin.
West Castles.
West
Castles. Application being made. That means tomorrow.
Tomorrow, my lord.
Yes. On the application as part of this court. On the application being made by the petitioner shall take up the bail matter for consideration immediately, preferably within this week itself.
Oh, my lord.
With above noted, as ordered above, the writ petition fully stands disposed of. Just special consideration. Otherwise,
My lord. It is a fit case for a special consideration. I'm deeply obliged, my lord. I'm deeply obliged.
Apply a law.
Daily list item number 1.
Number 1, Mr. Mansoori.
Number 1, my lord.
Entering appearance today. There's an appeal. Yes.
So, my lord, the service is complete now, my lord. I'll pray for LC records, my lord, and paper book.
What is this?
This is a land acquisition appeal. We come against the award, enhancement of award, my lord.
Enhancement, how much?
My lord, 100 times, sir.
100 times?
My lord, the collector has fixed 8 rupees at the relevant point of time, and the court has enhanced up to 140 rupees. So I have produced evidence. Sale deeds were exhibited. So based on that, my lord.
Where is the land situated?
Land is situated in Beltoli, your lordship.
In?
Beltoli.
IBBF.
Oh yes, my lord.
Yes, Mr. N. Mansoori has entered appearance today on behalf of the respondent number 1. As such, and you are appearing for? As such, notice. Yes, and our colleague is present on behalf of the respondent number 2 today. As such, notice on is complete on all the respondent stuff. Next para call for the records of what's the records already been received. No, come court last time. Yes, is records. Has the records already been received? Who will prepare a paper book?
I'll prepare.
The records already been received. The appellant is directed to prepare the paper book within 4 weeks. Yes.
All right. The interim order.
Interim order.
It can be until further orders. Well, but the award will take effect in August.
You can finish the hearing by August. If you undertake this court ready to finish the matter by this month itself, you can prepare the paperwork. No issues with the court. We can dispose it of. Let the paperwork be prepared first. Yeah.
Item number 2.
Interim order. Obliged.
Interim order continues for the orders. Yes. Now, please let the court understand one thing first. Is this a same stretch?
Same stretch.
Same stretch.
Same stretch.
This is this new bypass.
New bypass.
This is coming from what's this place? Sumer.
Sumer.
It exits on
to the
Soyong. Total length is
about 36, 37 kilometers.
The length?
At the stretch.
37 plus one stretch.
And in the lead case, my lord, the
respondent in IJITCL last time sought time to file a affidavit.
Okay, this is first we're taking up 474.
My lord. Yes, my lord. In this case, the respondent yet to file affidavit. State has filed, my lord, earlier occasion. So my
legal issue, my lord. Stand. It's the same issue, my lord. Simple issue, my lord. My friend can argue because it was kept for final disposal today.
No. It is fixed for filing of the affidavit. Other side.
My lord has indicated that matter will be heard.
Other matters.
All these matters, my lord. In all these matters, your lordship have said that the matter will be heard and decided, my lord. And that
What is the order one?
this was their whole case is, my lord, that the land compensation determined by the collector has been revised by the state government, and therefore, and that revision is wrong, and the award under which they have received the compensation without protest should be revised in terms of internal correspondences between state government and collector, my lord.
Now you says yes, I remember. What happened? There was one assessment by the collector, and then your contention is that arbitrarily it was reduced to
yes
a certain another amount.
My lord.
Have you received the other amounts?
They have received the amount. My lord.
You received the amount.
My lord. What happened? My lord, collector has fixed the amount. For example, 10 rupees. He determined it, and he sent to the government. Government approved it. And later on, my lord, perhaps central government said it is too excessive. So internally there was a communication, and they said for review petition review, and the collector reviewed the amount and give less than 10 rupees. So the primary grievance of petition is that they are not asking for enhancement. They are asking for whatever you determine first under the law. But there is no review power.
What law covers that?
My lord, that those are judgments are there. I pray, my lord, only if other side NHITCL is not willing to file affidavit.
You're not going to file affidavit, Dr. Mozika?
Other matters I've already filed.
That even those affidavits will suffice to address this issue here also?
Well, basically here what happened when this land was proposed, madam. So we NHITCL makes a estimate proposal, madam, how much will be the cost of acquisition and how much is the cost of construction. So we sent a proposal to state government. State government gave us an estimate of 682 crore rupees on account of land compensation.
That's the entire stretch?
Entire stretch.
For land compensation only?
Now what happens, madam, when they actually acquired the land, they sent us an estimate of 1227 crore rupees. That is almost double, madam. Then we wrote to the state government that this is beyond the viability of the project. Because the cost of civil construction is also involved, and the total project cost itself is the land acquisition cost. Then the state government, there was intervention by the Ministry of Road Transport, Minister of Road Transport, Bangalore, and the chief ministers of various states, Bangalore, and the land compensation amount was reduced after that. And the reduced land compensation has been received by them without protest, Bangalore, and now they are coming before this honorable court for various technical grounds. So that's the whole case, Bangalore.
Not the one that Mr. A took the money of Mr.
Yes,
B.
they have taken in all these.
All of them
now also Mr. A taken money of the amount
all of them,
Mr. B.
all the individual landowner
Mr.
received.
B took the money of Mr. C.
Yes,
my lord.
But that
reference is under sections.
Those this court not go into.
Reference is under section 64.
We know the broader aspects of what
exactly.
is wrong with the you saying that the reduction in the compensation. But if that's submission made by
my lord, that remedy is under section 64 of the Act.
But I don't dispute with regard that adjudicated forum is available. Only grievances, my lord. Here the requisition authority give a proposal that I want to acquire this land, which is estimates.
What do you want now, Mr. Changreso?
My lord, to pay the amount fixed by the collector.
Award,
I would satisfy
amount has been paid in terms of award. Amount has been paid in terms of award. Award is not in question, my lord.
Award is in question. That is the issue.
The award is in and enhancement of compensation will go under section 64. Your lordship, kindly see the Act.
I humbly pray that other respondents are not willing to file. I'll pray for fixing on Monday or Tuesday. We'll file a short rejoinder to the state affidavit and matter may be disposed of.
Because that affidavit has been pending for so long.
No, not so long. Recently we
I just see this court will be clear. What will be the only issue before this court? Because with regard to enhancement or other issues, you can go there. There's enough remedy under this act only. Correct. Now, what is you feel in which way have your rights been violated that you're seeking interference under?
My grievance is, my lord, once the collector determined 10 rupees under the LA Act. He has no review power. I'll satisfy to the Supreme Court judgment. My grievance is that he reduced from 10 rupees to 7 rupees. So my grievance is that one only seeking my lord intervention, direct the collector to pay 10 rupees. Otherwise, well, if I say that 10 rupees is too less, it should be 15, 16. I should go for reference
We have
for.
a lot of support that.
But I should have gone for reference.
Under the second award, and that too without.
And it's the only award. I will say that's the only award, not only award.
Then my friends give a statement that they don't want to file affidavit. That case, my lord, I'll file my short rejoinder
Dr.
process.
Muzika submits that.
A week's time will be fine after.
Then first you want to dispose it off. Now you want time till Monday. Now not a week.
I was ready on the.
But if your lordship disposes of the other matters, item number 16 to 19, that will come under revenue case.
Legal issue is common in all these matters, my lord. Legal issue.
Common. No, I'm
legal issue is common.
Taking a statement made at the
Legal
bar.
issue is common, my lord.
It was a common legal issue only on that point, that whether the collector was competent enough on his own, at his own level to reduce the amount assessed. That's the only thing.
But that is the legal issue.
One more fact which I need to add here: award is only one award, my lord. As the compensation has been given in terms of award, notified by the collector.
He'll have to address that hurdle.
I'll address that issue.
Then fix up on Tuesday. You had the whole matter.
Tuesday, Wednesday, my lord. Wednesday.
Wednesday, okay. On hearing the learned counsels in these, what is it called? These are connected matters.
In 21, my lord, only one slight different issue is that the private party is contesting. Petitioners are saying that the compensation which has been received by the private respondent should not have been received by private respondent. But the legal issue is also common in the sense that all these matters.
No. That's section 30 dispute, inter-party dispute.
Inter-party dispute. That will go again under section reference. Legal issue is section.
Your lordship is taken up item 21. I'll give some submissions.
You want to take up today?
No.
Can we segregate it from the other matters?
Is that it has no connection with the other matters.
Then we segregate it.
Yes.
Then that means item number.
My lord, item number 1, 2, 3.
Fresh matter today you file?
Fresh matter, my lord, may issue notice.
Supplementary.
Then we'll issue notice on that one first.
No, my lord, again they will say that counter has not been filed in 2 and 3.
No, we will make
one issue.
And rejoinder and next date again adjournment.
Item number 2 in the supplementary.
Same petitioner is filing one petition after the other, my lord. Fident has filed 474. He has filed second petition also, my lord. Same cause of.
What about what happened in Arunachal Pradesh?
Different districts. Different districts.
One person, he made all his documents and which after the article has been paid. What if you wish those 16 to 19? Yes, Kanika, 274/2025, item number 1. Number 1 today.
Number 2, my lord.
Number 2.
Supplementary number 2.
Yes, number 2. Somebody just to stop. Heard Mr. H. Naroso, when is in a council with Mr. Swanson. Issue notice. Acting Generals present on behalf of the. Behalf of the
1 to 6 in 2.
Number
1 to 6, 1 to 4.
1 to 6, my lord.
1 to 6. And Dr. N. Muzika, the SDI, is present on behalf of the remaining respondents.
These matters are, I don't know which today's matters.
It's more or less same matter.
My lord, regarding this, will lordship attention. My lord, is the learned members of the bar are facing problems.
The thing is that, see, if we segregate, this matter goes its own also, this other judgments will be, hopefully if the matter is heard on Wednesday, will cover this also.
Only my lord.
Yes,
only with regard to notice.
And Mr. Dr. Muzika, who is appearing others similarly in similar matters, is present. Also accept notice on behalf of respondents as such. No further notice called for. Stop. The incident matter, as submitted by the parties, is connected to other matters which are already pending in this court, namely the MPC number 474 of 2024 and others. Yes. Stop accordingly list this matter together with the other connected matters on the next date. Stop. So that's take care of it. Then with regard
to Lordship indulgence, may I just bring a Lordship attention with regard to the letter submitted by the NHIT cell to the registry. In view of that letter, my lord, the learned members of the bar are facing a problem. The registry is not allowing the learned members to file.
No, already instructed the deputy registrar that there's no question that they'll be accepted. Who's NHIT?
Exactly.
You've alerted them. Yes, you've given instructions that you just settle the matter with them. They can't give directions that to the registry that the council should first give advance copy to NHITCL before the matter is accepted for filing.
Some of the interference with justice.
Order. Well, you instructed the listing section.
Grateful.
That when it's filed, it's it'll be accepted. Yes. Yes. 474 matter stuff. Matter. Mr. H.L. Chanreso, but he has made out to file a short rejoinder to the affidavit filed by the state respondents. So, stop next paragraph. Dr. M. Muzika, on behalf of the respondents number 7 to 9 submits that no affidavit necessary in this present case, as the affidavit filed in the other.
I'll file by next day. In 3 days I'll file.
Yes, on Dr. Muzika please that he may be also to file a affidavit within 3 days. Stop. Accordingly, this matters on Wednesday for admission hearing along all other connected matters. An endeavor shall be made to dispose of these matters on the next day. Right. Yes. Grateful.
Item number 4.
I'm praying for 1 week's time.
This is the electrocution matter, my lord. On the last two, the matters pertaining to the electrocution matter in Norman Song. So, on the last 2 occasions, my friend has seek time for filing an affidavit.
He's in bereavement.
What detailed affidavit?
Should I have no instruction from this?
Since there's urgency in the matter, my lord, it's a legal aid matter.
Lordship, 1 week's time.
Yes, as the conducting counsel is not available, we have the response to in 3 days after 1 week. The expected detailed affidavit been filed. Not been filed. Deal will be on board on the next day. Yeah.
Item number 5.
Yes.
My lord, this contempt case is filed against the order dated 1/5/2024, my lord, which has not been complied with till today, my lord. This is the matter of benefit ACP and MACP about the cipher category, my lord.
The number 77.
But on the last occasion we submitted that the matter is under consideration.
What instruction of Ministry of Finance have you got?
But the last update was on 5th June only, but they're saying because there are several cases from different high courts, and they're considering all the entire batch of matters. But the last instance is active consideration. Some more time will be given.
Yes, we'll give you last. We just adjourn for 3 more weeks. We'll see after that. Yes, Dr. M. Mozika today has again apprised the court that as per last instruction received in June 2025, the matters under active consideration and Ministry of Finance stop. As it is submitted that the orders are being complied with, right? We'll record that.
It's under consideration.
Because
there are different orders passed by different high courts, including Guwahati High Court and Manipur High Court.
Yes. And I can consider the rest after 3 weeks. We'll see after that.
Item number 6.
Give your law.
Madam, my lord, I need some more time, my lord. Let it come after 4 weeks because
Why adjourning the matter before division bench?
My lord,
Last time we were ready
some
to take it up.
discussion was going on, my lord, between the parties because of that. Maybe this is the contempt, my lord. So again, this week it is coming up.
Close the contempt.
No, Your Lordship, because
You're not willing to hear.
no,
the
no,
appeal
I'm willing, Your Lordship, because he said that the court also he said that authorities are discussing on the matter. I said if they can resolve outside the court.
Request of the parties list after 3 weeks.
Lordship, much blessed, Lordship.
7.
Please, Lordship.
Still to file the rejoinder.
Lordship, rejoinder will be filed in course of the day, Lordship. You have served advance copy, Lordship.
You've served here.
Your Lordship, I'm appearing on behalf of Mr. Philemon Longri, Your Lordship, for respondents 5 and 6.
He's a petition. He's a respondent here.
Respondent, Your Lordship.
College of people.
You file affidavit.
Yes, Lordship. Will
Yes,
file.
Your Lordship.
You file rejoinder to the affidavit.
No, Lordship. I'm praying for 2 weeks' time, Lordship, to file the rejoinder to the affidavit filed by respondent 5 and 6, Lordship.
Just now you said that you
respondent
file
3,
rejoinder
Lord.
to 1 to 4.
Yes, Lordship.
Today. When did you file affidavit? When did they file affidavit?
2nd of May, Lordship. 2nd of May, Lordship. 5 and
They
6.
filed 2nd of May.
Yes, Lordship.
The other private respondents.
Yes, Lordship.
Then we won't allow it. Rejoinder is not by right. Is it necessary?
Lordship, give us 2 weeks' time, Lordship. We'll be filing, Lordship. Yes,
As prayed for the 2 weeks' time to allow the petitioner to file rejoinder affidavits. The affidavits filed by the respondents. Yes.
Clear, blessed, Lordship.
Item number 8.
Please, Your Lordship. No, this is an application for extension of time of the arbitration proceedings, Milord. Under section 20.
Last time it said you wanted to examine the affidavit. So, what on examination? What has come out?
We have seen, Milord, they are primarily objecting to the brother having been substituted in place of the original claimant. But that substitution was done. We have annexed the order also, Milord. That was done quite some time ago on the 26th of December 2024. And that was never agitated, Milord. That is at Annexure 3. Otherwise, Milord,
Annexure 3. Order 26.
There's Annexure 3, Milord. Order dated 26 December 2024. Now, from para 3, Milord. On 23/11/2024, the claimant's brother who is seeking substitution was present without his consent, and the respondent was represented by Mr. Devobrato Bhattacharjee, AGE Contracts, G1 Air Force Shillong. This tribunal, with the order dated 23/11/2024, directed the parties to file their submissions in writing on or before 7/12/2024. On 6/12/2024, the applicant seeking substitution filed his submission in writing through his counsel, Sri DG Pingrove, which was received via email. The respondent also filed their objections in written, which they have mentioned as written statement on 7/12/2024, which was also received by email. The point of consideration here is whether the brother of the claimant, who was unmarried at the time of his demise, which is not contested by the respondent, can be substituted in the instant reference. The primary objection of the respondents is that the applicant seeking substitution in his application for substitution has not produced any succession certificate or legal heirship certificate in his favor for representing the deceased claimant. To buttress their contention, the respondents have relied on condition 1E of IAFW 2249, General Conditions of Contract, forming part of the contract agreement, which, according to the respondents, defines a contractor as reproduced herein below. The contractor means the individual or firm or the company, whether incorporated or not, undertaking the works, and shall include the legal personal representative of such individual or the persons composing such firm or company, or the successors of such individual or firm or company, and the permitted assigns of such individual or firm or company. The respondents further submit that from the aforementioned condition of the contract, the legal representatives or successor of the contractor can represent the contractor. However, such representatives or successor, without producing of any valid document, cannot be considered to be the successor, and the epic card submitted by the applicant seeking substitution is not a valid document to prove legal representation or succession, and as such the application dated 22nd August 2024 is not maintainable. The applicant seeking substitution, on the other hand, in his written submissions dated 6/12/2024, contends that Section 40 of the Arbitration and Conciliation Act 1996 provides that arbitration agreement shall not be discharged by the death of any party to the agreement, but shall remain enforceable by or against the legal representative of the deceased party. It is further contended that in terms of Section 40 of the Act, the arbitration agreement between the deceased claimant and the respondents continues to subsist and is enforceable by Sri Pradut Kanti Chakraborty, the legal representative of the deceased claimant. It is also submitted by the applicant seeking substitution that Section 2(1)(g) of the Arbitration and Conciliation Act 1996 adopts the definition of legal representative from Section 2(11) of the Code of Civil Procedure 1908, and in terms of this definition, a legal representative is a person who in law represents the estate of the deceased person. The applicant submits that the deceased claimant does not have any Class 1 legal heir as per the Hindu Succession Act 1956, and the applicant seeking substitution, being the biological brother of the deceased, is a Class 2 legal heir, qualifies as a legal representative, is entitled to represent the estate of the deceased claimant under law, and is competent to represent the deceased in the instant arbitral proceedings. From the contention of the respondents, what emerges is whether, in terms of the contract between the deceased claimant and the respondents, the brother of the claimant can be substituted in the absence of succession certificate or legal heirship certificate. The instant proceedings came into being on an application made by the deceased claimant, Mr. So-and-so, under Section 11 of the Arbitration and Conciliation Act, filed before the Honorable High Court of Meghalaya, which was disposed of by the judgment dated 2/5/22, passed in arbitration petition number 2 of 21, appointing the sole arbitrator to adjudicate the reference between the parties. During the pendency of the reference, the claimant unfortunately expired due to a sudden brain stroke on 23/6/2024. The reference is at the stage of evidence and has substantially progressed. However, the same has not culminated into an award, and as such the contention of the respondent that the brother of the deceased claimant, applicant seeking substitution, cannot be substituted in the absence of a succession certificate, legal heirship certificate, is not correct, taken into consideration Section 40 of the Arbitration and Conciliation Act 96, which unequivocally states that the mandate of an arbitrator shall not be terminated by the death of any party by whom he was appointed. An arbitration agreement shall not be discharged by the death of any party and shall be enforceable by or against the legal representative of the deceased. There may be some substance in the contention of the respondent that the applicant seeking substitution has not produced any succession certificate, legal heirship certificate. However, such contention could have arisen if this reference had culminated into an award. The instant reference being at the stage of evidence, such contention does not arise. The applicant seeking substitution in his written submission has rightly pointed out that the respondent's objection that the succession certificate is required for substitution is misplaced. Such certificate is only required for claiming debts and securities that have been ascertained and determined, and in the instant reference no liability or quantum of payment has been adjudicated. Similarly, a legal heirship certificate is required after the death for transfer of ownership or assets of a deceased person to a legal heir. Therefore, production of a succession certificate and legal heir certificate at the time of substitution in proceedings before a court or any tribunal for that matter is not necessary. The application dated 22/8/2024 filed by the applicant Sri Pradut Kanti Chakraborty seeking substitution in place of the deceased claimant late Partha Pratim Chakraborty is supported with an affidavit along with a copy of the death certificate issued by the competent authority. As such, I find no reasons to disbelieve that the applicant seeking substitution is the biological brother of the deceased claimant and qualifies as a legal representative under the law. Thus, the application dated 22/8/2024 filed by Sri Pradut Kanti Chakraborty is allowed and Pradut Kanti Chakraborty is substituted as claimant in the instant reference in place of late Sri Partha Pratim Chakraborty. Now, this, my lord, was in December last year. So thereafter, my lord, he was substituted, the matter was proceeding, and we have given in our petition, my lord, the sequence. So, adjournments were sought and times were asked for and all that. Finally, my lord,
say one thing, Mr. Roti, that they adopted dilatory tactics.
my lord, too many adjournments and too many things have been sought for, my lord.
The thing is that their objection was overruled with regard to the substantiating the credentials of the person sought to be substituted, correct?
Yes, and that has never been assailed.
That was never assailed.
That was never assailed.
So then what, Dr. Moses, why will they extend it?
Well, the only thing, my lord, the question of substitution may be left because the learned arbitrator
How
also
can you
held.
open? Because if it's already decided, you have not come against that.
But even the learned arbitrator said, my lord, because this is at the evidence stage. At this stage, it is not necessary to examine that aspect.
But then, when the award comes, you'll contest at that time substitution. You could have to contest.
But
it.
if they succeed and who will be entitled to the amount, my lord, that question should be left open. In the humble submission.
Once the substitution is done,
that's what arbitrators held. They have not held this out also.
It can't be so conditional that okay, let one person contest the matter, and when the fruits of litigation are about to be plucked, you say no, you can't take them. Can you put a person to such? Can you put a person to such trouble?
Even the learned arbitrator said so.
No. Look what the learned arbitrator said. But the thing is that once substitution is allowed, it follows. How can you say that the question will be left open, that poor fellow will conduct arbitration proceedings on behalf of deceased brother or the company, and then after the award is published, it won't be, he can't avail of it.
My lord, in that case, my lordship will not say anything. Let the arbitrator dwell on this issue when
the time comes.
Appropriate time comes.
If at appropriate time comes, if they come up with some legal issue, that's a different issue. My only submission, my lord, regarding the delay, my lord, in the proceedings, as made out in the petition, my lord, they have not said anything.
When did they get over the term?
22, page 26, lots you will see, my lord.
26.
Or the order of the learned arbitrator, para 14.
Page
26, para 14. May I read, my lord?
Okay, yes.
This tribunal, by the order dated in paragraph 16 of the said order, has decided the mandate of this tribunal in terms of 29A of the Act shall lapse after 12 months of completion of pleadings. The pleadings have been completed on 2/2/24. The mandate of this tribunal will stand terminated on 1/2/25, my lord.
So they extended arbitration for 6 months. That means it'll go till August.
6 months extension was not consented to. 6 months extension can be done only by consent of the party.
Yes, but by the arbitrator. He didn't consent to that also.
That was not consented to.
So what happened? You see, the party that requested to give the consent in writing for extension, he didn't give that under 29A3.
We gave the consent, they didn't give. So thereafter we came with this application.
So after it just got stuck there.
My lord. So we came with this application for extension.
We extended for 6 months.
For?
6 months. Is there an outer time limit on this? There's no time limit.
There's no time. Whatever time your lordship is pleased to give, if an observation is given that it must be completed within that. 6 months, 1 year.
Yes. Take down.
Obliged.
Yes. Anything else? Anything else to say?
Well,
Yes, sir. Why is it a term number which in this case arbitration?
Miscase, my lord, because, my lord, originally the arbitrator was appointed by this Honorable High Court, my lord. So, in that original case only, for appointment of arbitrator under Section 11, I think.
Okay, it was appointed by this
In
court.
that only a miscase is. Otherwise,
arbitrator was appointed with this honorable court, my lord.
Under 11.5.
My lord.
Justice Banerjee, Chief Justice.
Yes. This application, listeners, application has been filed under section 29, capital A, bracket 4, praying for extension of the mandate of the appointed arbitrator beyond the prescribed period, inasmuch as the same has lapsed on
first of February
1/2/2025. Mr. S. Chakravarti, Leonard, Senior Counsel for the petitioner, submits that this court, by an order dated 2/5/2022, in arbitration petition number 2 of 2021, was pleased to appoint the arbitrator as a sole arbitrator to adjudicate the disputes between the parties arising out of a contract. He submits that in the course of the proceedings, the who died?
Original claimant.
The original claimant.
The original claimant. What's his name?
Partho.
During the proceedings, the original claimant, late Partho Pratim Chakravarti, sole proprietor of the construction company, died, and he was substituted by his brother. By the order of the tribunal on 26/12/24. However, he submits, as the mandate expired on 1/2/25, and there being no consent between the parties for extension of the time, the petition has been compelled to come before this court by variance in application. Like by Dr. M. Mozika, Leonard, Senior DSGI, Senior Counsel, has submitted that the what is submission? Sorry.
But primarily submission is that he is not the competent person. Substitution.
He submitted that though the brother of the deceased claimant,
the class 2 hearings is not entitled,
has been substituted by the tribunal, the respondent had questioned the same, but however, as the tribunal has ruled as such, he has no submissions to make at this stage. At this stage, as it's only as stage stop. Having heard the counsel for the parties, it appears that the matter has been delayed inasmuch as there was no consent given by the respondent under 29A bracket 3, 29A 29 capital A 3 for extension of the period specified in subsection 1 of section 29A. Therefore, in this view of the matter, as the matter has come before this court, and in consideration of the matter in its entirety, also take into account the order of substitution passed by the tribunal, it appears that the matter has been delayed due to the substitution proceedings before the dismissal is stopped. Accordingly, the mandate of the sole arbitrators is extended 1 year.
6 months would be sufficient.
1 year?
6 months.
By 6 months, okay.
From today, Mala.
Yes, it's extended for a period of 6 months from today. It's made clear that whatever questions that are left, whatever any other questions may be raised before the tribunal itself.
Regarding substitution, madam.
Any other questions? You might have any other questions. Matter of only stands disposed of.
Item number 9.
One thing, would your lordship make an observation that effort should be made to complete it within this?
No, we can't let it tribunal. You 6 months.
All right.
No, 1 and 3 are filed.
No, please, Your Lordship. Lordship, we're
Close
supposed
it.
to. No, Your Lordship, we're supposed
Why?
to file return. We need 1 week time, Your Lordship.
Yes?
1 week more time, Your Lordship.
What 1 week more time? Where's MSZE no country? You already submitted that your matter is structurous.
No, Your Lordship, the what?
You've already gone before the reference court.
No, Your Lordship, the subject matter which was referred to the reference code and what we are claiming here is completely different, Your Lordship.
What's different? You come this side, we can't hear you. You are allowed to file a
My lord,
joint
here the
justice.
dispute is between MECL, my lord, and the petitioner as to the ownership of the land, my lord. Now that has to be decided in the appropriate forum.
Your Lordship, for reference code, they're saying that the matter is for adjudication between parties, Your Lordship, which is MECL and us, the petitioner. However, Your Lordship, our claim is that our land does not fall under the land acquired by the MECL during the 1960s. So the matter is not, there is no adjudication. 1960s, yes, Your Lordship. As claimed by them in their affidavit.
Where's your prayer? Let's see.
Lordship, the prayer is for compensation, Your Lordship. This compensation will not be.
It has to be by as per your
until the
prayer.
matter in the reference court is settled, Your Lordship.
Your Lordship, this rejoinder is very important. I may be allowed only 1 week time, Your Lordship.
It's important. You more now should have filed it well within time.
Your Lordship, there was there's a confirmation required regarding the demarcation of boundaries, Your Lordship.
No,
That's
we're
what the
asking
delay.
out here only for statutory compensation beyond 1/3. Okay, yes, a further 1 week's time is allowed for rejoinder. You file expected next day, the rejoinder should be on board.
Highly approach.
Item number 10.
May it please Your Lordship. Lordship, I humbly pray for further 2 weeks' time, Your Lordship, to find my rejoinder.
How many times you prayed?
This is the second time, Your Lordship.
Yes, I prayed further 2 weeks time is allowed for rejoinder. Yes.
11.
After answers.
Highly obliged, Your Lordship.
May it please Your Lordship. Lordship, I am entering appearance on behalf of the newly impeded respondent number 2, my lord.
Respondent number?
Respondent number 2. I am the second wife, my lord. I'll file my wakalatnama in the course of the day, and I may be allowed 3 weeks time to file my affidavit. my lord.
What's the matter about?
My lord, this matter is about a pension matter, my lord.
About?
About a pension matter, my lord. I am the legate wedded wife of the.
Number 2 is who's number 2?
She's the
I'm
second.
entering
the
appearance
second
for the
wife.
respondent.
Mr. M. Ahmed has entered appearance today in behalf of respondent number 2. He responds allowed 3 weeks time to file affidavit. This is the reference.
Much obliged.
Highly obliged, my lord.
12.
Please, Your Lordship. Lordship, this is a pension matter, my lord, and the state has filed their affidavit. So, in view of the affidavit filed by the state, my lord, I humbly pray that the matter may be disposed of, my lord.
Where's the affidavit, Mr. Moment?
I've already filed, my lord.
Where is it? What have you said?
Received your affidavit.
Where is it meaning? What have you said in affidavit?
Para 7, they said they'll be releasing the pension, my lord.
Where is that?
Para 7, page 2.
Please, Lordship. 1 second, Mr. Sama. Let us one at a time.
Para 7, my lord.
Para 7, my lord.
Short affidavit.
Yes. What do you have to say?
This same subject matter is pending before the District Council Court, Your Lordship. This annexure, may I take my rejoinder affidavit is annexure 1.
Rejoinder affidavit?
No, affidavit in opposition. Sorry, Lordship. There, it is. This is the
He's
case.
So used to being a petitioner's lawyer. That's why.
So there, this same subject matter case is still pending. So that there's an order where it's a stay order also. So trial is still going on, and they have issued, and they also is appearing. May read the order, Your Lordship.
This is criminal revision.
Yes, my lord.
Then?
This is under section 127 CRPC. This is a different subject matter, my lord.
Not different subject matter. May I read the order, Your Lordship? It is the this one.
Yes.
Not criminal revision. This is regarding this one only. The order is very clearly stated.
Why was the order stayed? What order was stayed? You stayed which order?
The earlier order,
What was the earlier order?
Order of the District Council Court, where it has dismissed my criminal application.
Yes.
We have filed an application.
For maintenance.
Yes, for maintenance. That's
dismissed.
Dismissed.
What connection does this have with pension?
This is for regarding the pension only. Because he is yes, asking for 50% of all the benefits. Lordship.
You take your chances with the department. Yes.
Lordship, may I just take on the next occasion?
We'll record your submission.
No, Lordship, because this same subject matter, Lordship. I have mentioned in my affidavit in opposition also.
Let's see
that order is stay. Just read a part of the order.
Why have you not annexed where's the petition? Where's your petition filed before the lower court? Where is it?
I have not annexed the order, but the order I have enclosed.
Where's the order rejecting your application?
That my order is not rejected. This is the additional judge has.
Then why have you come appeal for the additional judge in this order? You annexed this order of stay.
Because there in the additional.
What does the first order say?
First order says that my application for 50% was rejected. 50%.
Over.
Then we file an appeal. Now that appeal is still.
Appeal memo of appeal.
That order is there. Lordship, on the next day, Lordship, I will. No, Lordship, I'll produce you, Lordship. Lordship, kindly give me a 1 week. No, it is not. No, this is only for.
We are already paying their maintenance, my lord.
No, they are not paying any maintenance, Lordship. Only for the interest of justice on the next day, Lordship.
No, my lord.
Are you denying that he's not entitled to receive pension? Are you denying that?
No,
listen, is he entitled or not to the pension?
He is not entitled, but I'm the first wife.
Please
I'm the first wife.
Please listen, what are you praying for?
I'm saying
You're
that
praying for that you be given a portion of the pension that comes to him for your maintenance, correct?
Yes.
Now, where will remedy lie? Where will remedy lie?
We have.
Is it correct to say that now because this matter is pending, stays pension, you won't get any money also?
No, Lordship, I will try. I will satisfy all the query of the court only for the interest of justice.
No, my lord.
Since I am not prepared to do
this is totally against the interest of justice.
No, Lordship. I will.
Listen. See, you're not in advisory capacity. I'll not advise you. But you have ample other methods if you want to. Even this matter can go on. Your matter before the council court, there's no stay on it. It can go on. If you get an order from there that he pays 20% or 10% of his pension, he has to pay. That's it.
I will produce the lower court order address, Lordship. I humbly pray, Lordship. Only Lordship. They have not even supplied a copy of that rejoinder, Lordship.
Respondents.
Government.
Mr. Movement. Respondent number 5. 1 to 6. Stop. The moment AGM submits that in view of the averments made in the affidavit of the state respondents that the pension are terminal benefits of the petitioners be raised at the earliest, nothing is left for consideration in instant matter, and prays that the matter be closed. Stop. Mr. A. Movin also. What is this?
Lordship. On the Mr. P.T. Sharma for the respondent number 5, however, has argued that there was an order, Lordship.
Please, enough. We've heard you. For respondent number 8, has vehemently objected to closure of the case on the point that there are proceedings before the District Council Court with regard to payment of maintenance of the respondent number.
50%.
We're not getting maintenance. Has any decision come from the court? Next thing, one scrap of paper. Yes, sir. Please, enough of submission with regard to payment of maintenance to the respondent number 8. Stop. Next one. This court's peruse of materials as also the affidavits filed by the state respondents. Stop. Who have stated that the retained benefits will be released at the earliest. In consideration thereof, the petition is closed. Stop. With regard to submissions made by Mr. P.T. Salma, it appears that the same misconceived as the proceedings for his council court have no connection or link with the payments of the due to the petitioner state respondents. It is not that. Respond yes. You pursue remedy. Your remedy is open. It's not been closed. Your case is not been squashed.
Lordship,
Yes.
that order.
It is expected that the said pension shall be settled at the earliest. Yes.
At least time frame may be granted, my lord, or else
There will be a period of 2 months. Yes.
Lordship.
13.
Hello, oblige, my lord.
Yes.
My lord,
Where's the rejoinder affidavit? You're not filing with Mr. Kumar. He's frozen. Yes. 2 weeks further time. For rejoinder. Yes.
14.
For 14 of frame, some time. 10 days time. 10 days for affidavit.
The fresh matter.
Yes, Your Honor. Yes, Your Lordship.
Urgency.
Yes, Your Lordship. Actually, there's one more post which is still pending, Your Lordship.
Which
That's
post?
The post of Havaldar Clerk, Your Lordship.
10 days time will file out.
You were selected.
Yes, Your Lordship. In the previous one, you were selected.
Dr. Muzika, please respond the 10 days time to file affidavit. Further 10 days time expected. And then like list after 10 days positively. Yes.
15.
But here there was a direction. There was a direction by Your Lordship, my lord, to the last order.
This matter is not resolved till now.
It's not been resolved.
No, Your Lordship, there is a. They have not resolved it, Your Lordship. In the meantime, there has been a development, Your Lordship. I'll pray that Your Lordship will decide the matter today. Either way, the reasons of that, I have been selected in a permanent post in ESIC. And
You have a new job now.
Yes, Your Lordship.
You're not just Negrims anymore also.
No, what happened in Negrims, I was selected against a reserve category post, and that was for a temporary period. Now they have again advertised that post, as I have not joined there.
No, but then now the orders of this court are operating whereby your joining date will be extended. They'll have to accept
No, that post, I'm producing it before Your Lordship. Your Lordship will, see, Your Lordship, what has happened is that...
Then you close it, you withdraw the petition then. You take your chances with your fresh post.
No, I am praying for a resignation, Your Lordship. Your Lordship will decide my prayer this way or that way.
Yes.
Your Lordship will kindly, I'll just hand over a bunch of papers to you, Lordship. Your Lordship will kindly appreciate my predicament, Your Lordship.
What about the ministry has not decided till now?
It's not decided, my lord. Yesterday's communication, my lord, they've sent one person specifically to ministry to follow up the matter, my lord.
Not to it also.
Who has sent?
From the Assam office.
What is what do you want to show? Mr. Singha, what is this?
Your Lordship, this was the advertisement made by the Health Department, Assam. And I appeared on 24/6/2025 for the interview. Now, when I appeared for the interview, they said that we are not going to accept you because neither you have a release letter or nothing. Now, the next page is the advertisement for the post. Oh, I'm sorry, sir. Sorry. Now the next page is the advertisement which was 14/6/2025 by the ESIC. Now your lordship will kindly see page 3. Where the main problem lies, your lordship. Age limit. Has your lordship got it?
Yes.
Number 2, for senior resident, not exceeding 45 years. So wherever I go, your lordship, in very soon I'll cross this 45 years and I'll not be able to apply anywhere.
You applied, you've already been selected for this also.
Yes, your lordship.
What's your age now?
Your lordship, I'm 44 something. Your lordship, he's a very bright student, your
Are you
lordship.
turning 45 tomorrow?
Very soon, your lordship.
When's
And
the
now
birthday?
no. They'll not wait for me, your lordship, anymore.
When are you turning 45?
I think, your
know
lordship,
that.
I'll have to verify it, but I'll cross
Put
45.
an affidavit, you take it next week.
Your lordship will kindly, hear for me for a moment, your
We're not
lordship.
here because if you change circumstances or the same circumstances, we can decide the matter. But on this, you want to bring on new facts.
I'm not bringing on new facts.
The negligence issue is not alive anymore.
Your
Because
lordship
the
will kindly
entire
hear.
writ petition is based on the premise that I have to join negligence, and I'm not getting the green signal for resignation. Correct?
Your lordship will kindly hear for me 5 minutes, your lordship. Rather than 5 minutes.
Yes, well, that was the premise of and that's why the relief has been granted by Lordship, my lord. Negrims has kept the post vacant.
Your lordship will kindly hear for
I'll
me 5
communicate
minutes.
that to them
My
also.
entire prayer is that they are not allowing me to go on resignation. The law does not debar me. And what is that? What has culminated that? They are playing with my career.
Playing with a career, but after last day's hearing doesn't mean that there's no option for them to refuse your request also. It's a question of functional retirement or resignation, that after a complete certain amount of years, retirement entirely on my accord. It is not like that.
No, it's like that, your lordship.
It's not like that.
Let me satisfy your lordship in that case.
It'll take 1 hour.
I'll wait till 4 o'clock if required, your lordship. Your lordship will kindly see the issue.
They should file an affidavit, my lord.
No. I'll file an affidavit. One, my respected friend is senior. What has happened? They have taken it as ego SL. On 1st of May, I have submitted it through proper channel. Your lordship will allow me to complete me.
Please.
No, your lordship will direct my respected senior to allow me to complete
Case is
me.
premised on something else, my lord. They bring in something new.
No, nothing.
They should bring on affidavit, my lord, these documents. my lord.
Please listen. It's okay. Please try to understand, Mr. Singha, right?
Yes, your lordship.
Now you're trying to bring on board change circumstances, correct? With regard to the urgency for your demand for resignation, correct?
Yes, your lordship.
At least you owe the courtesy to the court that it comes by affidavit.
Exactly.
Before you press your prayers. Everybody who comes before this court has a grievance. And to every person, remember that, to all lawyers also, for every person, no matter how big or how small the case, that case to him is the most important thing in the world also. So we understand your anxiety, but things you done correctly. Why have you put an affidavit in the morning itself?
I could have put it on affidavit. No, the person
Then
is.
the court can consider, because those circumstances have to be considered. The larger picture have to be taken, not in Negrim's aspect. That this person now is running from pillar to post. He's applied for Assam, he's applied for ESI, he's applied for Negrims, desperate to get out from Assam Rifles. That will come the whole picture.
Your lordship, the
You
desperation.
expect this court just to swallow everything, that this, just do it, it's my case. It's so urgent. I'm prepared to wait till 4 o'clock. Good submissions. The court just directly you file an affidavit, will take after 1 week. Yes.
Your lordship,
When is your birthday?
Your lordship,
Learn counsel for the
he needs to
they may
take
allow
on
to
leave,
bring
your lordship.
additional documents by way of affidavit. This is the matter after 1 week.
Your lordship has not directed them, they are not producing anything, your lordship.
Yes.
In that case, your lordship will at least protect me to that extent that ESA has directed me to join by 30th.
How can you take cognizance of these documents you produce without any affidavit? How do you know, in these days and age, you think you can take cognizance of any document that's produced? Mr. Sneha, please try to understand. The court doesn't want to be terse with you. Please file an affidavit.
Your lordship has not directed them to produce they are not getting the relevant instruction in spite of that.
Just now he said latest instructions, they're still sitting, even I give you hassle, we don't know. Please, yes.
Then your lordship will decide it this way or that way.
Item 20.
Yes.
Lordship, I filed an application to
Who
stay,
has filed?
to vacate that order, impugn order, Lordship, on the last occasion.
We received copy, we filed show cause on it.
This,
File.
yes, I have filed it, Lordship.
Private person has filed.
My lord, in this
Because
case,
in this case, Your Lordship, because trial is going on, they are trying to avoid the statement of that the trial is going to evidence. I have clearly stated out of 8, 4 have been completed. Another 4 witnesses they are not bringing. They are not cooperating with the court. That is the problem. Now instead of cooperating with this one, I have enclosed the annexure. They have filed a list of witnesses, Your Lordship. I have enclosed it also. That is a page 52. They have filed a list of witnesses as per the instruction. What I got it, they said out of these witnesses only 3 evidence has been recorded. Another 5 they have not, even the petitioner himself, the Tinda, he is avoiding 2 or 3 occasions. He has not come for taking the evidence, Your Lordship. So they are unnecessarily taking it because there is a clear from the court order also, as well as from the High Court, as well as from this one, to take evidence. Because there is some issue has not been recorded, that's why. But from our side, we are the appellant in the lower court. We have given all our witnesses. We have completed. Our evidence is completed. It has been recorded. It is on record. I have stated in my petition also, in the miscase application petition in para 2.
my lord, on this case, we will file our show cause, my lord. Now, my lord, here the records will be necessary, my lord.
It's not record.
The district council has not yet filed the affidavit till now, my lord.
My lord,
we have made.
My lord, district council has not filed an affidavit. Let me at least submit. My lord, here there was a personal allegation level against the CEM, my lord. So I have taken an instruction. He has requested me to appear for him also, my lord. We'll file 2 affidavit, my lord. Probably within a week we'll file our affidavit, my lord.
My lord, the records also will be necessary, my lord.
Moreover, my lord, the allegation which has been leveled against of CEM, my lord, that an agreement was made for whoever wins the arcing matter will get a compensation. And the way the petitioner has projected that the CEM has personal interest on this, my lord. This is the practice which is going on in the district council, my lord. When there is an arcing matter dispute, there is a dispute, my lord, then to take over the land, my lord. Because until unless the land is handed over to the deputy commissioner, my lord, they cannot process of the construction of road and all, my lord. For that purpose only, my lord, the agreement was signed. And agreement was not forcefully made to be signed by the petitioner, my lord.
File affidavit.
We'll file our affidavit.
You want to file show cause?
Yes, my lord. In
After 1 week.
I will file my affidavit within a week.
My lord, in the meantime, records may be called for, my lord.
In this case number 150 of 2025, introduction number 160 of 2025. This is an application for vacation, alteration, modification order dated 6/5/2025. Passed by this court. Actually, the order is still today,
my lord.
Yes. Oh yes, order is only for till today, for the next day. That means
what kind of application should you file in that event? You can't vacate because the order is still today only.
Yes, because it is in the continuance of that main order. That's why. Yeah, because this order is continuing as per the order dated this 06/05/2025.
Here in this
on the basis of that.
But other courts, there's certain applications that are filed when the orders only till the next date.
Yes,
but they file an order to not continue the order, the interim orders.
Yes, I humbly pray that this interim should not continue.
Okay. The interim order, let the interim order continue. And meantime, my lord, the records may be called for, my lord.
The cost may be imposed?
No, my lord. Records may be called for. Records will be necessary in this case, my lord.
When the matter is already stayed, my lord, we'll produce the record when it is required.
In W160, this is an application for vacation alteration of order dated 6/5/2025 by this court, filed by the respondent number.
I'm respondent number 5 and 6.
5 and 6 as applicants.
4, 5 and 6.
Mr. Kisi Gautam, please we allow only stamp to file show cause the same.
4 and 5. Lordship, there is respondent 4 and 5, my sir. 4 and 5.
In the main case, Mr. SD in the course of the filing.
No, within a week, my lord.
Submits the affidavits on behalf of
all the respondents, my lord. We'll file on behalf of the respondent number 1, 2, and 3, my lord.
1, 2, and 3 shall be filed within 1 week.
What do you want?
This is matter after 1 week for
Lordship.
My lord, I have a further prayer. The records may be called for.
We'll be producing, my lord, definitely. It is arcing matter, we'll produce it.
Will be present with the record the next
yes.
day.
21.
Let it be reflected that he will be present with the record on the next.
Already, my lord has
Already
passed an order.
just now.
My friend has some.
21.
Much praise, Lordship.
Yes.
Lordship, in 1921, we have taken steps upon the.
Lord, in this
4, 5, and
case,
6.
One second. Let
in
us.
this case also, my lord, the prayer, if your lordship will kindly see the prayer, prayer is questioning the entitlement of the private respondent, my lord. Your
What
lordship
is one that belongs to some lady? And
yes, my lord. So now that if your lordship will
what
see,
it belongs to the village.
It belongs to the clan, Lordship.
Oh, sorry.
Now,
clan.
the person who is acting as claiming himself to be the
5 and
Bakur
6.
Lordship, he had issued
Right, the husband of the.
petitioner. Lordship.
but this issue, my
Of the
lord,
private respondent.
Private respondent.
my lord, in this issue
So
also, my lord,
despite our objection, despite our representation before the collector, Your Lordship, or the DC, the DC has released the compensation.
Money is already gone.
Lordship.
so then your lordship will seek section 64, my lord, section 64 of the act. Section 64 will help my friend. Any person interested who has not accepted the award may by written application to the collector require that the matter be referred to the collector for determination of the authority as the case may, whether his objection, any person,
Okay, fine.
and then my lord, if the collector reference is not made to the collector, the application can be filed before the authority directly for making the application. So if the case of the petitioner is, my lord, that he is entitled to the person to whom it is payable, because his case is that the payment should have been made to the.
It's not a question whom is payable. The question to whom has been paid to.
So then in that case he will have to.
The arbitrary actions of the respondents, Lordship, in
Because
releasing the
now
compensation,
under the
despite
notification,
objection by us, Lordship.
no, so therefore for that only remedy is under section 64 and 64 which says that you take this matter to the adjudicating authority constituted under the act, and then they will contest, they will lead their respective evidence, and then
return the money.
Recovery will be there. Recovery will also be there, because that is that under section 64 the authority has power to do it.
Where
You also kindly see the authority, power of the authority, my lord, section 60. I'll just place the entire chapter on, my lord, regarding section 51, my lord. Establishment of land acquisition, rehabilitation and resettlement authority, my lords. That this is the authority. And that authority has already been notified under section 51(2), my lord. The appropriate government shall also specify the notification, and the composition is also in consultation with this honorable court, my lord. Section 52, my lord. Authority shall consist of one person only, to be appointed by notification by appropriate government. Appropriate government may authorize the office, and then the qualification is 53, my lord. A person shall not be qualified for appointment to presiding officer authority unless he has been district judge or he has been qualified, shall be appointed by appropriate government in consultation Chief Justice of High Court in whose jurisdiction authority is established. 53 now. Kindly see.
No, let's come to the
60,
power,
my lord.
whether he has the power.
60, section 60. Section 60.
Power to
Section 60, my lord, it is a suit.
recovery.
It is a suit, kind of suit. Section 60, my lord. The authority for the purpose of its function under this act shall have the same power as are vested in civil court. Under Code of Civil Procedure, in respect of following matters, summoning, enforcement, attendance of any person, examining him in oath, discovery and production of any document, other material, receiving evidence of affidavit, requisitioning any public record, issuing commission and reviewing in any matter, my lord. And after that, my lord, reference is section 64. Kindly see section 64. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the authority as the case may be, whether his objection to be measurement of the land, the amount of compensation, the person to whom it is payable, rights and rehabilitation under chapter 5 and 6, or the apportionment commission compensation among the persons interested, provided that collector shall within a period of 30 days from the date of receipt of application make a reference to the appropriate authority. Provided further, where the collector fails to make such reference within the period so specified, applicant may apply to the authority as the case may be, requiring it to direct the collector to make the reference to to it within a period of 30 days. So, my lord, person to whom it is payable, and then your lordship will see the award is there, the challenge will be there, my lord. Then the issue will be before the authority to examine the matter, my lord. The authority, and therefore, if my friend is saying that under the law, his clients are entitled, and they are the true owner of the land, my lord, and the compensation should be paid to him. All these issues will be subject matter of evidence, subject matter of production of material before, my lord.
No, of course, that is there. That's what the court realizes. But the thing is, he's asking for action against who? Respondent number 5.
Respondent number 5. Respondent number 5.
Because our objection was prior to the release of compensation, Lordship. Our objections were on record, Lordship.
But that objection has been rejected by, and therefore the matter will go.
Asking you to institute parallel proceedings against the respondent 5 and 6 for misleading you.
No, that I don't have power, my lord. That I don't. That will be under the act only. Because if there are two claimants, respondent number 5 and 6 is one claimant and petitioner is the other claimant, my lord. And the money should go to whom? It is also subject matter of reference, my lord. Section 64. The person to whom it is payable. This is also by the district judge.
See what Pressure is asking is under 84.2. Just see 84.2.
Yes, my lord. Punishment for false. If a person in connection with the requirement of direction of this act provide any information that is false or misleading or produces a false document, he shall be liable for punishment, imprisonment of either description or term which may extend to 6 months or with fine which may extend to 1 lakh rupees. Any rehabilitation or resettlement benefit availed of making a false claim through the fraudulent means shall be liable to be recovered by the appropriate government in the manner as may be prescribed, my lord. All these will be subject to the finding by the adjudicating authority, my lord.
This is not independent of the 64.
No, this is not in, because that power, how will I, because there is a fraudulent action.
Has there been any other case like this?
I have not come across.
Under the new act.
Lordship, I'll have to do some research.
You troll.
Lordship, if the respondents may require to file an affidavit, Lordship, because
this is a legal issue,
whatever it is, but the thing is that, see,
yeah, because if there is, a case is
the bank account
is available under the
issue is
who's appearing private respondent. So you took the money.
3 crores, Lordship.
So whatever money.
Just yes.
But the bank accounts can be frozen and they can avail 64.
No, under which provision of law? I don't know. But how will you release private money? 226 is not power.
The compensation has been released to the court, to the clan.
There are 4 parcels here. With regards to parcel number 1, we have received the compensation. And with regards to the parcel 2, 3, and 4, they are still pending before the collector.
You do one thing. You file affidavit within 1 week.
File an affidavit.
No, very good 2 weeks time. Even the
You file on law also, Mr.
Yes, I'll do that.
You make a, yes,
yes, I'll do that.
Yes, this matter has been dealing from the other matters.
Yes,
and will be taken up independently.
I'll also file for number 4.
Mr. Allen Advocate General for respondents 1,
2, 3, Lord.
1, 2, and 3. Dr. Nwozika for 4 and Mrs. C. Sangma was just entered appearance on behalf of 5 and 6 are allowed 2 weeks time to put in the respective affidavits. After 2 weeks. If that's correct, then your land's still there. If what Mr. Sangma says correct.
The issue is let them file affidavit.
Hearing item 22.
Otherwise, we will take for lok adalat.
We have already made our submission, my lord.
See, wait, you're skating on thin ice. If they're willing to go ahead with it, then we'll remand the matter.
My lord, as per our appeal, my lord, we are only agreed by the part of the order.
You can't be agreeing with that because that is part the reference has been answered.
My lord,
if the reference has been answered, then once you send it back, they have not appealed against the award also.
That is
the matter is closed. And once they go back there, that means you open a Pandora's box again.
My lord, but
so you're ready to face a Pandora's box.
My lord,
Huh?
I'm not ready, my lord.
Exactly.
I'm not ready, my lord, because
see, once it goes back, Mr. Nauri,
yes,
the reference has to be answered afresh again.
Yes.
Then all questions will be left to be answered again. Forget about the 6-7 lakhs, which has been given to the. He has not appealed against the award.
He has not
He's the
appealed,
person who
my
should
lord.
have appealed against
I should
the,
have.
the award.
My lord,
But I made it
he
very
should have
clear
in
the
fact,
reason why I did not
appealed
appeal.
against the order.
Because, my lord, if my learned friend initially, my lord, I had raised an objection. I said that it is not an award. My learned friend said that it is an award because some amount has been enhanced. So we take it as an award. I took it as an award.
My lord, there was no enhancement made by the court. Here,
Now
my
That
lord,
is why.
Now we
So
say
that is exactly we're coming back to square one. What the court observed on the last whatever hearing is that if it's not award, then the reference that has been put before the reference court has not been answered. And if the reference has not been answered, then it goes back automatically to remanded back to the reference court to answer the reference as well. And answering the reference means you got away with only 7 lakhs, been given to him.
No, my lord,
Over and above the very meager amount that's been paid. He did not appeal because whatever personal considerations he had. But once it goes to reference, the whole field's open again.
if I can just point
And
out,
you're the requiring authority. Yes.
my lord, if I can submit.
So, my lord, if it goes back, then
My lord,
There will be Pandora's box.
now, my lord, my lord, may kindly see. It is not the fact that my lord award was not made. Award was prepared, my lord. Now, every time the matter has been referred before the court, it is not necessary that the court has to enhance it, my lord.
Not a question of enhancement. It's a question of answering the reference.
Yes, that is different aspect, my lord. I am not aggrieved by that. If claimant is aggrieved by it, my lord, they could have definitely filed for an appeal. Now I am
They have not
aggrieved.
filed an appeal, Mr. Singham, please I understand. They have not filed an appeal. That matter stands closed. The only grievance you had is that utility charge. What's it called?
Contingency charges, my lord.
Contingency charges
I'm aggrieved
that was not incurred has been factored into that amount and given to the 6-7 lakhs, given to the claimant.
Yes.
And he has not appealed against the non-enhancement of the whatever the award by the collector. Correct.
Yes.
Now it ends there. Now, if the reference is sent back, the whole will be open. You're ready for that?
I understand, my lord, that aspect.
Then
but
yes.
I do not have any instruction. as regards
Yes,
to
Mr. No, you're the counsel for the government. You have to advise them
that.
accordingly.
My lord, as far as that contingency charges is concerned, my lord, I have instruction that they cannot part with that money, my lord, because that is not claimant is not entitled for that money.
Then they'll be open again. The reference will be open again. Yes. Yes.
the contingency charges, my lord, that will be a question of law, my lord, whether the reference court can, my lord, direct payment to the claimant.
That is only pure question of law, my lord, that my lord already in agreement, my lord, that part of the order
See,
is
the
wrong.
filing of the court is not an award.
Yes.
Could have done that. Then it goes, the reference has not been answered. And every reference has been made must be answered as per law. Even limitation will not come in when the reference has been answered. Might be after 20 years also.
My lord, rightly or wrongly, my lord, the reference has been disposed of. Now against that only appeal will lie.
We're remanding it back, appeal will lie, we're remanding it back. Why? Because you say that the reference court had no power, they have to reappreciate everything, whether it had the power or not.
Well, I am okay with the fact that, I was okay with the fact that certain amount of money was enhanced.
It is not enhancement, my lord.
No,
Award has not been enhanced, my lord.
What I am trying to say, from the point of view of a layman, I have been litigating for a long time. I'm a very old man. I was happy whatever I parted with my land. Of course, I was paid a very meager amount of money. I wanted enhancement, but then, my lord, taking into consideration the fact I didn't want to get into any further litigation, I was okay with that. Thereafter, my lord, state filed an appeal, my lord. The state does not even want to give me that. Then I have every single right to agitate.
Which, my lord, claimant is not entitled. He cannot claim for that amount, my lord. He is legally not
Then
entitled.
answer my reference. Then my reference has not been
He
answered.
should have appealed against that order, my lord. He has not appealed. He is claiming relief on my appeal.
They should have not filed appeal also. I would have given a quiet test to the entire issue.
You're misunderstanding the whole thing. He has not filed appeal.
Yes, my lord.
He is a party to the proceedings, correct? So what the matter is remanded back to taken afresh, what happens?
That I am
What
aware, my
happens?
lord.
Then,
That I am
whether he file appeal or not, he is a party. He'll have to take part in proceedings and then he'll have a second chance to, ask for enhancement. Because
See, the finding of the reference code was that there was some tripartite agreement.
Right.
Never proved, correct?
Never.
Then?
And it was not, even the award was not prepared on the basis of that.
We don't know what you argue not doing the pitfalls, Mr. Khan, of reopening the reference. You are insisting on a finding that contingency clause is not payable to him. That's all.
No, my lord, that is.
You want a modification of the order to that extent.
Only to that extent, my lord.
Yes, very simple.
Very simple.
But then we remand it. We remand the reference. We'll remand it back. Because this finding on the agreement also is not.
It's incorrect.
That is incorrect, my lord, because if there is a agreement, my lord, then it is a consent award. I cannot even go and agitate. That is something which is, I also agree with.
Procedure is laid down, my lord, 11-2.
If your lordships kindly have page 33, this is the claim petition. Page 33. Next chip 2. Now, what has been enclosed along with this claim petition, if your lordships kindly have page 46. This is the agreement for it. Page 46. Internal annexure 5 to the claim petition. If your lordships kindly have page 48.
Yes.
At serial number K, my lord.
Yes.
Now your lordships will find 650 handwritten.
Yes.
So this was annexed along with the claim petition. Now if your lordships kindly have page 76, my lord. This was what we produced, page 76.
You produced that before the agreement, before the reference code.
Yes, ma'am. Now page 78. Again, if your lordships kindly have serial number K. It starts at page 76.
Yes.
Page 78, serial number K, my lord. Your lordships
Blank.
will see blank.
In fact, claimant
This was never
manipulated.
No. They cannot say that now. No evidence was left. They cannot say that. They cannot
They
say
have
that.
inserted this amount, my lord.
They cannot say that. That is just a pleading taken by them. They cannot say that because I was not given an opportunity of cross-examining or placing my point.
Even otherwise, in equity,
cannot
also,
say that.
they are not entitled for any relief.
They want to give me more, my lord. Let it be remanded back. I was happy with that.
Aside, then remanded back.
My lord, my submission is very limited, my lord. I am only agree by the part of the order, my lord. My only humble prayer is, my lord, if that part of the order may be strike off.
And what happens?
He's happy.
What happens if that part of the order is wrong? The whole order is wrong. Because see, the finding of the reference court is that since it was a tripartite agreement, there was no necessity for the collector to have incurred any contingency charges, and as such, the contingency charges is since it doesn't arise, that's your thing. So if why should be paid to?
Right.
It should have been paid to you.
Yes.
Correct. But instead, what is wrong is the collector, the reference court gave it to them.
Yes.
Now, if the very foundation of the fundamental thing, the foundation of the order is based on a document that's never been proven, which came the next finding that there was no contingency charges incurred by the collector, which comes to your appeal where you see that amount is wrongly paid, then the whole thing is based on a lie. Then if the whole thing is based on a lie, the award, if we set aside that part of the so-called award of the order of the reference court, the others will have to go also. It will naturally follow as a corollary. Because that contingency are not arrived at because the reference court relied upon an agreement was never approved.
And on the
and
other
the agreement was
hand,
never approved. That is why. So then the amount arrived at was paid wrongly. So then now with once reference opened, now his claim for enhancement, this document have to be proved. Now whether 650 was entered when, by whom, then
It was for the claimant, my lord, to prove the document.
he didn't bother. He not prove. He got the order.
Because I was not
He
given
said,
an
"I'm fine."
opportunity,
He
my
didn't
lord.
appeal against the award. You have come to appeal.
Yes, we are agreed by the order, my lord. We have come. So we are agreed by the part of the order, my lord.
Yeah, part of the whole award.
The entire order is.
Mr. Singh can't come back with instructions again. Maybe some.
He doesn't understand
My
implications.
lord, I have understood,
Yes,
my lord. I have already spoke to the.
What
collector.
you're losing now only 7 lakhs.
Yes.
If it goes reference, you might lose 7 crores. It's simple as that.
My lord, it is not only one case, my lord. Here there are many cases, my lord, where this contingency charges has been given to the.
No, but then this is
charged by the
totally
different
different.
Circumstance.
This is different from the
We'll
others
give you
because
one more opportunity, otherwise it's against public interest. Some litigation, the court deprecates is like, this is some sort of litigation again. Appeal by state government, against, anyway, which will cause loss to public exchequer in ultimate analysis.
My lord.
Yes, next matter. This after 2 weeks, I will want to send further instructions.
Obliged.
25.
Please, this is the matter concerning the construction of a road through the Rilbong Community Hall towards Umshirpi, which my lords had heard at some length. This is the second round of litigation, my lords. Initially, we had come before your lordships with an apprehension that our lands would be taken because the width of the road was very narrow. That matter came to be disposed of, my lords, because on assurance given by the state that no acquisition would be done. The issue that thereafter, my lords, what arose is, my lords, they are still going ahead with the project, and in spite of objections of the residents of the locality, my lords, because and which they, my lords, also agree in the proceedings before the PWD, that there these 2 schools are there, my lords. And yeah, my lords, there are these 2 schools which are situated in that particular road, which is now sought to be, my lords, the width of that road is very important, my lords. From 3 feet, from 3 meters, my lords, it's sought to be expanded to 5.2. That's what they say is going to be good enough for a single carriageway.
That's only 1.2 meters. That infringe upon your private land.
No, it does not. It's not a question of on the private land aspect that matters come to an end. What we're saying is, Millers, that if this road is opened up for Millers vehicular traffic, it will not only pose a threat to the residents of the locality, Millers, because that's the main road through which everybody is passing.
You're afraid it'll be a public thoroughfare for cars.
That's what they want to do. They want to make it a public thoroughfare for cars. And Malads, they say the only explanation that they give for protection of these children who go to school, and these are primary schools, Malads, the small children involved, they say we're going to put up adequate signages and zebra crossings for protection of these children. That's the issue in core before your lordships. Now the residents of the locality, Malads, have been agitating against this from day one, because earlier also, Malads, on this road there have been accidents.
The schools are party also.
Well, they are signatories to the objection that has been filed. As a matter of fact, I'll just take your lordships to one document that actually clarifies this entire situation. In the counter affidavit, if my lords kindly have a look at the Annexure 2, page 8. This is a letter dated the 15th of April 2021. There's the last page of the counter affidavit.
Page 20?
Page 8, Millers. Last page. This is a letter, Millers, from the Chief Engineer, National Highways, PWD Roads, Meghalaya. This is addressed to him, Millers, from the Executive Engineer. After study of the project, Millers, they say, with reference to the subject cited above, I have the honor to report as follows, that the aforementioned project envisage widening and conversion of the existing footpath into a motorable road, construction of an RCC bridge over Umshirpi River stream, which will serve as an exit route to the residents of Greater Laban area by avoiding the ever traffic congested junctions at General Rhino Point and Anjali Petrol Pump Point. That as a usual practice in all projects which involves donation or gifts from the landowners for extra land required for improvement and widening of the road, the onus is always with the Dorbar Shnom. However, in this instance, Maybe there was a communication gap perhaps between the formers and the latters prior to this proposal submitted by the local MLA. It may perhaps be mentioned that the undersigned had received an advance photocopy of the petition dated so-and-so addressed to Your Honour, in which the signatories had categorically resolved not to part with the land for the said purposes. Taking cognizance of the issue, the local MLA so-and-so conveyed a joint inspection on 27 February 2021 with the PW officials along with other officers from Shillong Cantonment Board, Shillong Municipal Board, members of the Dorbar Shillong Rilbong locality and residents of Greater Laban area. After verification of the availability of right-of-way of the existing footpath alignment, etc., it was observed that the existing side drain is it was observed that if the existing side drain is covered with an RCC motorable slab, the existing footpath will widen to an average width ranging from 3 meters to 5.2 meters. Therefore, considering the land constraint and this being an important road in the city which will however greatly benefit the general public, it was unanimously felt by all members present that the available width of the road on completion will be good enough for one-way traffic. Much more is it is a fact that there are 2 numbers of schools situated along this road, and the signatories of the petition were apprehensive of the safety of the school-going children. However, care will be taken for provision of safety measures such as speed breakers, road signages and road markings like zebra crossings, etc. at different vulnerable locations so as the safety of the pedestrians and the school children is not
Now only one thing, the construction is over.
The construction is in progress, Your Lordship. It is going on, Your Lordship.
What is the public interest, Mr. Paul?
My lords, public interest, I bow down.
Yes.
But public interest, my lords, cannot go to an extent where, my lords, a footpath is, my lords, converted into a road. My lords, jeopardizing the safety of children.
Greater interest of a larger.
My lords, greater interest. My lords, if I may, I just ask this. My lords, if I may just ask this question to myself. Your lordships are absolutely correct, my lords. Greater public interest would, my lords, prevail upon any individual interest.
Yes.
But here the question is, my lords, a school and school-going children would come within the realm of, my lords, greater public interest. There has to be some kind of, my lords, balance that has to be struck between the public interest and, my lords, because this is conflicting public interests. If I may put it so, my lords, it's not a question of private interest as against public interest. It is conflicting public interests. My lords, the incline at which the road is, and as your lordships have seen, they are building the road by covering a drain. Bare minimum width, my lords, available, with the kind of traffic flow that we have in Shillong. Well, it's God forbid if any one child were to get injured, or, my lords, something worse happens.
That's exactly the consideration that they're having.
My lords, signages and zebra...
Because of the congestion.
My lords, signages and zebra crossings would
Laban it's a terribly congested area. You'll know, you're the best.
My lords, I bow down.
To know.
I bow down. But it does not serve any. My lords,
if any.
My lords, the point that I'm trying to make is
taken for for decongesting by creating. How can the court interfere?
My lords, if I may, if your lordships are aware, this is the road, my lords, which goes from the Rilbong junction and opens up, my lords, in the Umshirpi point, my lords. That's that Jhalupara point, as we very popularly call it in Shillong.
Okay.
It is an arterial road, my lords. Whatever is written over here, my lords, being a resident of that particular area also, we can say that it does not affect any of the people living in Greater Laban. Because for any person...
What is written the exit, you don't have to come to Rhino Point, then you can take the exit.
My lords, for anybody to use that road, we'll probably have to go right up to Rilbong and then probably come down from there, my lords, and proceed towards Jhalupara. And that also, my lords, considering that there is a eternal traffic, my lords, at Jhalupara. That's besides the point, my lords. I cannot argue this on this matter. My concern here is, my lords, and the concern of the locality is that with this footpath opening up for, my lords, vehicular traffic, and the kind of vehicular traffic we have in Shillong, my lords, the safety of these children and the residents of the locality, my lords, it's a 5-meter wide road.
I mean, it will be how much?
5
the length of this dais.
I'm sorry, my lords.
The length of this.
No, it'll be lesser than that, my lords.
More than this.
No, it'll
More
be
than
lesser.
that, Your Lordship. 5.20.
As a matter of fact, my lords, the residents had conducted a survey of that particular stretch, my lords, and it was found to be 5 meters only at certain points. In most of the areas, my lords, it was lesser than 4.5 meters.
Yes, what do you have to
May
say?
it please, Your Lordship. This matter had been taken up, Your Lordship, in the earlier round of litigation, Your Lordship. The subject matter is the same, Your Lordship. The objection they have raised in the annexures they have attached to this writ petition is also the same as in the earlier round of litigation. This order was passed, Lordship, by your Lordship's order dated 1/4/2022 was passed on the basis of a joint inspection. It is annexed in the writ petition.
Which page?
At page 30, your Lordship, annexure 4.
Yes.
There was a joint inspection, your Lordship, in February. All the stakeholders and the residents of that area were also participated in that joint inspection, your Lordship, and it was unanimously agreed that there would not be any need for taking any private land. So it was agreed that the one-way traffic would be constructed on this road, your Lordship. And we have stated in our affidavit, your Lordship, that necessary precautions will be taken for the safety of the children, school-going children and the pedestrians.
Yes.
Speed breakers will be... And your Lordship, by your Lordship's order dated 1/4/22, your Lordship had said that the matter was settled and it was disposed of, your Lordship, and it was because at Parrot 2, your Lordship has stated, in view of the statements made in the affidavit by the state respondents at this stage, nothing survives for consideration by this court. However, petitioners are at liberty to agitate in case fresh cause of action arises. Where's the fresh cause of action, your Lordship? The matter was disposed of and adjudicated in the first round of litigation, your Lordship. And it was a consensual order,
There's
your
no
Lordship.
consent.
No, the court has,
There's
you
no
have
consent.
not objected when the matter was disposed of.
My lords hold that there's nothing, sir.
There was
Why
a
for
joint
consideration? That's a
inspection, your
different issue
Lordship.
for
There was a
consent.
joint inspection and the residents of that area also have participated in the inspection. They have not objected after that.
You put in proper signages. We'll dispose of
Signages and
Well, it's
speed
why-
breakers,
why-
everything will be
First of
there.
all, you know, even
Because-
if you go up your road, the drains are covered on both sides.
Everywhere the drains are being covered, your Lordship,
That,
to increase
you
the
know,
size of the
I'm
road.
a resident of a locality where we drive through drains rather than roads.
We just don't go to Laban anymore.
Both sides, yes.
We drive through drains rather than roads.
It's your
our
MLA,
only,
yes.
our only apprehension is.
We will put in.
Well, it's just
we will,
one issue, if your lordships kindly.
we'll put in orders, you know, specifically.
We have
Because
stated in our
on
affidavit
that-
also, your
on-
Lordship,
on
that all
that
these
particular
precautions will be
road,
taken.
Well, there have been accidents and there have people who have lost their lives on that particular road.
It's very steep.
Lordships are aware, of the terrain of Shillong. So there have been on 2 occasions, even while parking of a vehicle, there have been motorable accidents and people have lost their lives.
If there were no vehicles at that point of time, then I don't see how the accidents occurred in that road. Now only we want to make it a one-way traffic,
What has
vehicular
happened-
road, your Lordship.
What happens is, probably my learned senior is not aware. It's till a certain point in that road, it was motorable even from earlier days. Till the Rilbong community hall point, it's motorable. That's where accidents have happened and people have
But
actually
not on
lost
that
their
particular road.
Small field is there.
Not that field is there, the Puja Mandap is there, your Lordship, but
That is
not
where
on this particular road
No,
where
that
we
is part-
propose to construct
this
the
is
road.
part of that road. This is part of the road. This road, goes down, as your lordships would be aware,
We are
once we
aware of
go
that.
down from the Rilbong Puja Mandap, then the road turns left and then it again turns right, and goes straight down and there's a stairway till it goes and meets the Ushirpi River. This is that particular road. And on those 2 junctions, there are these 2 schools and there are roughly about 600 children studying on the school.
Yes.
That will be taken care of, your Lordship.
We'll dispose the matter.
This is just...
The other
Yeah.
aspect, of course, is
There's that
little-
Lumparing road which has become a
there's-
vehicular road now, your Lordship. That
Lumparing
is also very
different.
steep.
No, Lumparing
That is
very
also very
different.
steep,
It's
your
not
Lordship.
populated like.
No, it is populated nowadays. Even Malki is there.
Jaya or not, they've done that.
Everywhere it is
Those
being
where
done,
the-
your
even
Lordship.
2 people could
This is
pass
only
now,
for the
you find cars coming.
with the purpose of easing congestion, your Lordship, on the main
Yes.
roads.
No, your MLA also is very.
The paradox of the situation is, is that the roads have not decongested, rather that we have congested it more.
We have 8
Well,
lakhs
it's one issue
number
that
of
we wanted to
vehicles in
just
Shillong.
highlight before lordships, that insofar as this project, at the time when it was conceived or even at this stage, since it is still at this stage of construction, the law requires, of course, not particularly with this issue, there's this issue of a social impact assessment that is to be conducted by the government with regard to any project. Now, insofar as this project is concerned,
You're not acquiring any land,
I
your
am not
Lordship.
sure that whether any such impact assessment has been done, especially considering, when the project was conceived, and I can take a lot
What are the name of the schools? You kindly give it.
the 2 schools are, one is
We just
P.N.
take on your
Chaudhary,
submissions.
one is P.N. Chaudhary Higher Secondary School,
the other one.
Yes.
And the other is? I'll just give the names.
There are 13.
Is there? Of the
The
petition.
names.
Okay. Yes. Right. Yes.
Rilbong LP School.
Rilbong LP School and PN Chaudhary Higher Secondary School.
Right. Okay. Yes. Next matter.
Well, this issue of social impact assessment has never been undertaken. Probably, that's something that ought to have been undertaken by the government.
That is not a as
That is
altogether.
when, if a land is acquired, your lordship.
Environmental, so on and so forth. Is what it's anyway.
29?
Not go there.
29.
Yes.
Obliged.
Yes.
Your lordship, they'll be appearing online, your lordship.
I don't see anyone online. Yes.
Instructions on the fact whether there's a vacancy or not. This is that review medical case.
Well, by last note, I was directed to have instruction on whether the post is still lying vacant or not. So my instruction is that
Is available or vacant?
it's not available, madam. Because what happened, this was the recruitment rally of 2023. So once he was medically disqualified, my lord, this vacancy was added in the recruitment rally of 2024 and subsequently filled up, my lord.
Please, Lordship, that is incorrect because in the subsequent recruitment rally for the state of Chhattisgarh, there was no vacancy advertised for this post. And I can place that on affidavit. I can place that notification.
See, because we.
No, Chhattisgarh will not always remain Chhattisgarh, my lord. This is a recalibrated.
A tentative view is that you consider a review medical board for him. That's all.
My review has already been done, my lord. In this case.
And he's fine, found fit.
My lord.
He's fit. Oh yes, he's found fit. Yes. He went to Delhi, right? That's where the test was done. Correct.
Yes, your lordship.
Please, Lordship, the review was conducted and I shown to your Lordships last time that the review was not in concordance with the guidelines in as much as no neurologist was associated and no.
Now the review medical board will be.
Yes.
Yes.
A fresh medical board.
You put an affidavit if there's a post vacant, then there's no need to go for the exercise.
There is no
to
post
pass
vacant.
on all.
Well, what happens, my lord?
You're sure there's a post vacant? How do you know?
Post
Please,
remains.
Lordship, I am sure because this post was never advertised in the next recruitment.
You put an affidavit within 1 week. It was possible.
But the review is already done on page 18.
No. The thing is that there was no neurologist present.
Neurologist.
But these are very minor. Person can't be deprived of employment. There's a minor.
Tremors. And I told you, Lordship, from the guidelines, it says that not all types of tremors are disqualifying. It is only of a certain nature which are disqualifying.
You're sure there's no vacancy?
My lord.
Or that's just easy answer given by the.
But it says, my lord, that because this was pertaining to recruitment rally of 23.
23, yes.
So the post remained unfilled because of his.
This is which state?
Chhattisgarh, my lord.
This is for Chhattisgarh?
My lord.
Yes.
Okay.
Now, instruction is that this vacancy, because it remained unfilled, my lord, it was included in the next recruitment rally of 2024.
The vacancy of Chhattisgarh?
My lord, that is not necessary because every year is recalibrated, my lord, depending on the states, my lord. So Chhattisgarh will not always remain Chhattisgarh, my lord.
Please, Lordship, but that very vacancy of state of Chhattisgarh has to be then taken into account.
What is the process? Suppose now vacancy for state A, correct, is not filled. Is it carried over? It is
not carried over as such, my lord.
Then?
My lord, next year, for example, for a particular post, there are 30 vacancies, my lord.
So now when's the next recruitment rally?
24 already held, my lord.
24 already held. 25 we have a recruitment rally, that means.
Should be, my lord.
No, the thing is that suppose for state A you have 2 vacancies, they're not filled.
So maybe those 2 seats were allocated to state A this year, my lord. But for some reason, it depends on the total number of vacancies also, my lord. It depends on total number of vacancies. For example, next year there are only 8 seats, my lord. then state A will not get 2 again.
No, but the vacancy doesn't get carried
But
over.
vacancy is not carried.
So
To
that
my
means that
understanding is not
suppose
carried over
they
that
are,
way, my lord.
we don't understand.
Well, SC, ST, that way it may be carried over, my lord. But state-wise, in my humble submission, that's what I mean, is not carried over as such, my lord.
What do they call it, the guidelines that you follow in these matters?
Please, Lordship, if then it is not carried over, then it's actually in my favor because that's a submission that for that year at least the seat was kept vacant because nobody other than me was selected because none else could qualify the typing test.
What is the procedure adopted?
My lord, there are horizontal as well as vertical reservation, my lord, for every post.
What's horizontal?
These are horizontal, my lord, state-wise, and vertical is SC, ST, OBC, and general category, my lord.
What happens to, just simple question, is not filled up, I mean that the quota of the state goes?
For that particular year, my lord. Now this will be put in the pool, my lord. Again, some kind of recalculation will be done.
Never be filled. So some states where it can't be the quota, they won't have the requisite people coming from there.
But that particular year, my lord. It's not that, my lord, Maharashtra will be allocated 10 seats always, my lord.
No.
So
we understand. Suppose this year Nagaland has been given 2 seats.
But
okay.
if not filled up from Nagaland, my lord.
So this year no candidate from Nagaland qualifies.
My lord.
Then what happens to that vacancy? Also
next year's vacancy will
after there's no good becomes 0.
My lord.
Becomes 0.
For that particular year will become 0, my lord. Next year will
recalculate. Next year,
suppose
won't come Nagaland again, becomes 0 again.
Maybe next year Nagaland gets 1, my lord, or if the number of vacancies are more, they might get 3 also, my lord. That will depend on the availability of candidates. It appears to be.
What kind of roster is this?
He's probably begging meant for one state
it is complicated,
carried forward to another state.
How?
Well, vacancies are not carried forward, my lord, state-wise, my lord. SC, ST, maybe there will be this provision for carrying forward.
Please, in fact, if your lordship will see the advertisement.
Because this is not reservation as such, my lord. This is not reservation in strict terms of the policy of reservation. This is only to maintain some kind of balance between the states. Page 24, 25, 26, there are other tables, my lord, of that advertisement. How the seats were, how many seats were allocated to different states.
I'm looking for that. Yes, 1 second. C is Chhattisgarh. G. Okay. So in this year, this is the advertisement. This is dated 23, correct?
Yes.
Yes, sir.
The Chhattisgarh warrant officer 1.
Assistant was 1.
Rifleman 11 1. Havildar ORL 4. Mechanic 1. Then you come on the
warrant officer personal assistant.
First one. I can find out, my lord, what happened to this post, my lord. How it was taken to in 24 and how it was filled up.
Now, how do you see it's filled up now? Only that the only question that remains, because if we're not satisfied with the answer, then the post just gets
my lord, my instruction only says, my lord, because this post remained vacant, my lord, this was included in the 2024 recruitment rally and it has been filled up, my lord.
From Chhattisgarh?
From the next recruitment rally, not from Chhattisgarh, my lord.
Then?
Yes, that's the point.
Because see, one thing, Dr. Mozika, you see, after the very specific, as how many posts. Okay, like you see, that's why it's very interesting. Assam 18 together, Bihar 30, this gives Arunachal 34, 25 Andhra Pradesh,
And my lordship, my instructions are that in fact even under the 2024 recruitment rally, it was advertisement state-wise where the Chhattisgarh did not figure.
I can have some more instructions. Even the advertisement, there must be some stipulation in the advertisement. It's very small letters, I can't read properly also.
Yeah, that's what it's possible to read. Age of the accession.
In fact, if your lordship will see that there was in fact a corrigendum issued to this advertisement where this post was in fact increased. Please, your lordship would have page number 28.
There's a corrigendum, oh yes.
Yes. So your lordship will see that from earlier one it was made 2. And your lordship will see that the total was also increased from 14 to 28 with respect to the other posts. And as per my instructions, both these posts remain vacant because other than the petitioner, no one else could qualify in the typing test.
Why is somebody suffering from this kind of tremor disease, my lord? To appoint them in army.
Typing. Be faster than typing there.
And then your lordship, I can also place judgments of the Delhi High Court saying that even where the vacancy is unfilled, vacancy is filled, still a candidate would be entitled to appointment if it is otherwise clear to your lordship that there was some illegality in the process.
Let him come just once. Stop. It is submitted. Dr. Mbozika, Leonard DSG, I submit instructions that the post allotted to Chhattisgarh State of Havildar personal assistant are no longer available. Warrant officer is no longer available. Stop. On a query from the court as what happens to the quotas that remain unfilled of any particular state, as whether they carried over or they are absorbed into other whether they carried over or not. Dr. Mbozika, please be allowed to obtain specific instructions. This after 1 week.
10 days.
10 days, yes. This is 10 days. Then we'll pass orders.
Very.
Item 30.
My lord, in the last occasion, also we heard the matter, and this relates to the master worker, where he received also he is also the contractor. Contractor, and lordship directed me.
You better withdraw.
My lord, to produce the work order he received from the department. I just place, and in the meantime, I'll place the letter he has forwarded to the department to withdraw his.
Mr. Chanreso, not permissible. Yes.
My lord, in fact, asked him to produce where all he has been employed as a contractor.
And the letter he has forwarded to withdraw his contractual.
Yeah, they are being very kind by saying that they'll take you back.
He has withdrawn the contract.
He withdrawn?
He has withdrawn.
So we'll close it then.
But only my prayer to restore him back and grant him the RCW, which he entitled.
No, we don't got anything. Let you are enjoying yourself. You're enjoying other contract.
The contract paper, Lord, can you see?
Oh, he's doing supply also. See?
These are few orders received for.
How can he do this, Mr. Chanreso?
My lord, can you see the small quantity of
doesn't matter. He's with elections.
But to create a seal, here's a till page number.
Whatever small work, there might be 1 rupee also. See, file boards, file covers, JK copier, papers, and
small quantity which he received.
98,000.
That is the last, my lord, page number 11. It's the highest amount which he received. Otherwise, my lord, the nominal amount.
He should leave master role. He should become a businessman. Seems to be quite adept. So,
since he has withdrawn, that, and the impugned order asks him to withdraw that one. And department has received it.
Yes.
And only the impugned order, my lord, is because of that reason.
Where's the impugned order?
My lord.
Being aggrieved with an order dated,
my lord, 23rd August 2024, page number 38.
The petitioner, whereby the services of the petitioner as master role has been temporarily suspended as he is registered as a contractor stroke supplier. The petitioner approached this court asserting the same. Stop. It is noted that the said impugned letter indicates that the petitioner was requested to withdraw his registration, and that only on the withdrawal of his registration as contractor would his name be reinserted as into the master role labor list. Stop. Next one. Today, Mr. Changreso has produced a letter dated 29/5/2025, whereby the petitioner has tendered his withdrawal or cancellation of his registration as a contractor and supplier with the necessary documents enclosed. The same it is seen also been accepted by the elective engineer (PHE Electrical Division July. Stop. In view of this development, nothing remains for consideration in the incident petition, and the same is closed. No directions.
But only my second prayer, if Lord should kindly consider.
No.
Permanent RSCW.
He is a very illustrious fellow. He can make his way. Yes, you record Miss Ain's name for the respondent. Yes.
Hello.